Number 114284, Stephen White v. State of Kansas.
May it please the court, Joshua Andrews on behalf of Stephen White. The brief history of how we got here is that Mr. White pled guilty to one count of rape and was sentenced to life in prison. He filed a direct appeal of his sentence and conviction, but his sentence and conviction were affirmed by the Court of Appeals. The mandate for that decision was filed on February 12, 2013. Now, the Appellate Defender's Office claimed that a letter was sent to Mr. White notifying him that his appeal was denied. Mr. White claims that he never actually received that letter, and there's no copy of the letter or any other evidence in the record which would support, one, that he did receive a copy of it or that a letter had been sent in the first place. But the Appellate Defender's Office did confirm through an affidavit that a copy of the mandate was never sent to Mr. White. So he was never notified by the Appellate Defender's Office of the mandate being filed. In January 2015, Mr. White...
Excuse me.
I'm sorry.
The affidavit says the letter was sent, but confirmed that a copy of the mandate was not sent. But was advice that the mandate was entered, was that in the letter?
It was not. The original letter said that the appeal was denied and we are not going to file a petition for review unless you tell us to do so. And that was the last thing that was ever sent to Mr. White. Now, the Appellate Defender's Office did not receive a response from Mr. White, so they did not file a petition for review. Mr. White argues that he didn't send a response because he never got the letter telling him to respond. And then, as I said, nothing was ever sent after that, so he was never notified of the mandate until in January 2015, he sent an inquiry to the Appellate Defender's Office asking what's going on with my appeal. And they sent a letter back on January 21st notifying him that they had previously sent him a letter advising him that the appeal had been denied and they weren't taking any further action. So then on April 10, 2015, Mr. White filed his 60-1507 motion, obviously well out of time of the 1 year time limitation required by 60-1507. So the issue that brings us before this court is whether or not a summary dismissal of Mr. White's 60-1507 motion as being untimely would result in a manifest injustice. Now, when this matter was argued before the district court and when it was brought before the Court of Appeals as well, at that time the Von Tress case defined what is manifest injustice, or at least provided the factors for the court to determine in considering what is manifest injustice. After the Court of Appeals issued its opinion ruling in June of 2016, the 60-1507 statute was amended to add a definition of manifest injustice. So I think that before we can even really determine whether or not manifest injustice would result in the summary dismissal, we have to first ask what definition are we going to apply to Mr. White's case.
Does it really matter here? Because what he's really complaining about is that the statute of limitations started running without him knowing that it started. So that's the reason for the delay, which is what the statute said. We're going to narrow this to the reason for the delay, but that's what we're arguing about anyway, isn't it?
I agree. I think I have the benefit of, in my opinion, succeeding under either definition, because I think the Court of Appeals noted that the first factor under Von Tress, which is the reason for the untimely filing, favored Mr. White. And under the amended statute, it allows the court to focus entirely on that one factor. And given the fact that he was not notified, and there's no evidence that he was notified that the time limitation started running, that it strongly favors a finding of manifest injustice.
Let's talk
So do
about
I,
whether,
go
excuse me.
ahead, Justice Barr.
I was just gonna say, let's talk for a moment then about whether the district court made a credibility judgment.
I think that the district court's credibility judgment was not based on. The district court's credibility judgment was based entirely on the fact that Mr. White's claim he didn't receive the letter was self-serving. But there's no way around the fact that any time you say something that benefits yourself, it's self-serving. That does not equate to not being a credible argument. And I don't think that the district court made any findings that would say, for these other reasons, we find Mr. White to not be credible. Instead, the district court moved on to all of the things that Mr. White could have done himself to try to track down what the status of the appeal was. And I concur with the appellate court that a layperson who's represented by counsel should not be expected to have to follow the status of their appeal, especially one who's an inmate in a correctional facility. And so as far as credibility is concerned, I don't believe that the district court did really make any credibility findings that we would have to give deference to today in determining whether or not this first factor supports a finding of manifest injustice.
The judge did say that it was self-serving, but then the same sentence goes on to say, after all, Mr. White admits to having received all other correspondence sent from the ADO's office. So that it strikes, the judge in essence said it struck him as strange that only this one letter would have missed. Isn't that really a credibility determination?
I mean, I guess my question, that's the way the judge interpreted those facts. I don't think that the judge made a determination that, I'll try to answer that. I guess I would dispute that is in fact a finding of a lack of credibility. I would argue that the fact that he admitted he received all of this correspondence, did not receive that one letter, and then actually sent a letter 2 years later asking what is the status of this appeal would be support the idea that he didn't actually get that letter. So
I understand the facts could be read a different way, but don't we have to read the facts the way the judge read them, the district court judge? Are we in a position where we can reweigh the facts in the way you're doing and suggesting a different outcome?
I guess the problem that I have is that I concede that we're not supposed to be reweighing credibility, that the district court judge is in the position to do that. But I believe that we can, this was a summary dismissal, and so what we're looking at is, can we look at it from the papers that have been filed and determine from the court pleadings and associated documents whether or not there's a manifest injustice. And I believe that the appellate defender's office affidavit confirming that a mandate was never sent, which is really what tolls that, statute of limitations or the time limitation of 60-1507, would be sufficient that even if, without reweighing the credibility of the statement that he never received the initial letter that his appeal was denied, we can still determine that the appellate defender's office never notified him of when the mandate was filed, which started that statute of limitations. And I don't believe that that goes into the credibility of Mr. White. That's something
on
that is...
the previous letter. You're saying that it's really the later letters not being sent that triggers the statute. So whether he did or did not receive the previous letter doesn't matter.
I don't think it matters as much, no. I mean, I would still say that not receiving that first letter supports his contention that he had a really good reason for not filing it. But being notified that your appeal was denied does not in and of itself tell you that it's time to file the 60-1507 motion. It's when you're told that the mandate has been issued that the time limitation starts.
But let's go back to the question about what the facts show here. Do we have to accept the fact that the receipt of other letters negates the non-receipt of this one? In other words, the judge said, well, you received all these others. I receive a lot of letters, but once in a while one gets lost in the mail. It seems like the disconnect for me is that it's not a logical conclusion. It's a faulty syllogism to say that you received all the others, there, ergo you must have received this one. And do we have to accept that under our standard of review, even if we think it's an illogical interpretation of the facts? Are we still bound by the use of those facts to make a credibility assessment? You understand what I'm saying?
I do, and I agree completely. And I think that was the point I was trying to make earlier, was that this doesn't really go towards credibility when it's not a, I guess, as you put it, a logical conclusion. I mean, you know, if a district court judge said, well, I believe you're not credible for this reason, and the reason is completely unrelated, then why should the appellate courts be bound by that credibility determination? And I would agree. And I think that the Court of Appeals noted in their opinion as well, so I'm going to borrow heavily from them, that in the prison system, there's a lot of reasons why a letter may not be delivered. And I go back to the fact that this was not a situation where he filed his 60-1507 2.5 years later and then tried to claim, I just never knew that the time started. He actually first sent a letter to the appellate defender's office saying, what's going on with my appeal? I haven't heard anything from you. And that's what triggered their response.
What the judge did a preliminary hearing in this situation. So what is our standard of review on this question?
Well, Your Honor, I believe that the standard of review is still a de novo review of a summary dismissal with a de novo review of all of the documents, the petition and associated documents that have been admitted.
Even though there was a preliminary hearing?
I believe so, because it still resulted in a summary dismissal. Mr. White was not granted the benefit of a full evidentiary hearing. Simply after the preliminary hearing, the court determined he couldn't go any further.
And do you have any case support for that standard of review applying at that stage?
I don't know, Your Honor. I cited in my brief, and I may have cited the wrong standard of review, the Edgar, I believe it was the Edgar case regarding a de novo review.
But isn't the determination, according to the statute, that the petition or the motion files and records conclusively show that the movant is not entitled to relief?
Yes, Your Honor.
That's what the statute says, and we have a summary dismissal that finds that. And so if we're going to review that, how can we review whether the petition, motion, and or the motion, records, and files conclusively support that if we don't look at everything? Why isn't it de novo to determine whether the judge was correct in saying that there was we know conclusively defendants or movants not entitled to relief?
I would agree with that, and I think that in this particular case, given the allegations supported by the affidavit from the appellate defender's office as to why he did not file, that you cannot reach that conclusion that there is no possible relief in this case. I believe that those show that there is at least the possibility of a finding of manifest injustice if you're not allowed to proceed. And further, that again, looking at the second factor under Von Trust, but the merits of the case, that there's actually a meritorious argument here with regard to whether or not he was misled as to the potential sentence at the time of the plea by both his court and counsel.
That is a question I had wanted to return to after your exchange with Justice Johnson much earlier, when you made the comment that you felt like you could win under either the new amended statute or Von Trust. And I just wanted to clarify, does that mean you're abandoning your other Von Trust points? But I take it you are not. You would still assert those.
I do, yes, Your Honor.
And so what's your argument that Von Trust does still apply?
As far as why it applies, this is, and I guess I'm going to preface this by saying I am somewhat maintaining Von Tress applies, because if I lose on that again, I think I still could succeed under the other one. But I believe that the statute, when it amended the statute, it essentially took away that second factor under Von Tress, which was I guess, defense that a movement could rely upon in order to save their 60-1507 motion from being untimely dismissed. And because of them removing that, what was a defense, it resulted in a substantive change to the law. And because it was a substantive change, then it should not be applied retroactively. If that
Yes.
makes sense.
Okay, let me ask you, if you would accept that the new amended statute does apply, is your interpretation of that the legislature intended to amend this case law definition of manifest injustice as being something that is shocking, or not just the ordinary error kinds of things?
I think what the legislature, in my opinion, what the legislature was doing was essentially creating a legislative fix to Von Tress, which allowed a movement to be able to argue for the merits of their case, even if maybe they didn't have a good reason that it wasn't filed timely and they're not making any claims of actual innocence. And so by amending the statute, they're saying, you can only focus on why it wasn't timely filed or whether there's an actual claim of innocence. And so the purpose of the amendment was to limit the Von Tress test, which I believe that was the legal, Von Tress provided the legal definition for manifest injustice up until the legislature amended their statute.
But the legislative amendment saying we can look at why it was missed doesn't really give you any guidance. I mean, it could be because he decided to sleep for 2 weeks. So where is the line of what is a valid reason for allowing recovery or allowing the process to proceed? Do we overlay that with that definition of from case law, or how do we interpret that?
I think so. I think that Von Tress actually would still be good law in the sense that it provides guidance on how to interpret the first and the third factors. The issue is with the second factor being removed, that's what made it a substantive change. But Von Tress, which says that the movement provides persuasive reasons or circumstances that prevented him or her from filing the 60-1507 motion within the 1-year time limitation, I think that we would still look to apply that to the new statutory revision as guidance on what the court should be looking at in making a determination whether manifest injustice would result in a summary dismissal.
So you would say that obviously unfair or shocking to the conscience terms from Von Tress would be overlaid in Factor 1 under the amended statute? It goes to the issue of the court's inquiry shall be limited to determine why the prisoner failed to file a motion.
I think so, yes. When the legislature came in and said this is what the court's supposed to look at, it didn't say anything at all about shocking to the conscience. What they were looking at is whether there was a reason why or if there's a claim of actual innocence. And that's now the definition of what is manifest injustice. The fact that the statute clearly says the court's inquiry shall be limited to determining why the prisoner failed, I think that's the direction on now what we have to do going forward to determine what is manifest injustice.
Sorry, Justice Luke, did I cut you off
No,
on your
that's
line?
fine. No.
Yeah.
You asked the same question I was going to ask.
Did he give the answer you were
He
looking
did. Well, I wasn't looking for an answer, but he gave an answer. So.
I hope that's not a bad thing.
No, it's not.
for? Any more questions? Thank you, counsel.
Thank you.
Oh, I'm sorry, I do have one question.
Were you counsel in the district court?
I was.
Okay, thank you.
Yes.
That's all I needed.
I'm sorry, and I don't know. I was counsel in the district court on the 60-1507. I was not trial
Okay,
counsel.
that's what I meant.
Okay.
Thank you.
May it please the court, Joseph Penny for the state of Kansas. I think I'd first like to address the matters that the court drew parties' attention to regarding the amendments to 60-1507, and then move on to how those impact the underlying case and maybe just kind of facts or circumstances regarding the underlying case in general. I would agree that, as the court noted in the Hayes case, that the legislative change with regard to 1507 was intended to abrogate or in some way limit the three-factor test in the Vontes decision, basically stripping out that second factor relating to the general merits of the claim, leaving only the first and third Vontes factors. I think that the legislative summary as well as the legislative language supports that. The legislative summary basically said, quote, this is to specify that for purposes of finding manifest injustice to extend the time limitation for bringing an action. Court's inquiry will be limited to determining why the prisoner failed to file the motion within the time limit, and also to whether there's a colorable claim of actual innocence. And then there's a definition for what a colorable claim of actual innocence is. I did take a look at the testimony, legislative testimony in this case, and I think that intent is inferred from there as well. Both the proponents and the opponents of the bill, all in their written testimony, cited Vontes, cited that as the currently controlling case law on the matter, and also indicated that this bill was likely to change that case law. And I think at the time that they had the testimony, the amendment only allowed for the reason for failure to file. It didn't have the actual innocence prong in. It looks like that came after the testimony, and maybe based on some of the opponents of the bill's testimony that really was an important factor, an important thing. So, looking at that, I think the question as it applies to this case is retroactivity. And I do think that's important because, if you take a look at the Court of Appeals case here, we've got a circumstance where there's a three-factor test. Court of Appeals found that the first factor did weigh in Mr. White's favor. However, the court found that the second and third factors weighed in the favor of the state. So, in kind of balancing those three factors, the Court of Appeals found that there was not manifest injustice, that the trial court's determination that there was not manifest injustice, which was for slightly different reasons, was not in error. So, it's significant here if we're paring that down to a two-factor test where there's one factor in favor of Mr. White and one factor in favor of the state. Looking at the Court of Appeals cases that have come out after that change, I think all of them that I've seen have considered the amendment to be a procedural change. State v. Dawson might be the one exception, and only because State v. Dawson didn't really go into any of the questions. They just kind of made note of the change, but then said they weren't going to consider the change because it came after Dawson's brief had been filed. But the fact that this is a procedural amendment doesn't necessarily answer the question as to whether it would apply retroactively, because even procedural amendments don't necessarily apply retroactively in cases where they would impact substantive vested rights of the parties. And I think the couple of the cases where the Court of Appeals has not applied this decision retroactively, Sherwood v. State and Noyce v. State, that's the reasons they didn't do that. They said that we're concerned that the rights of the petitioner are going to be impacted, so we're going to consider whether they'd be successful under the three-factor test, at least as part of this, perhaps considering the two-factor test as well.
Are you asking us to apply this retroactively or not?
Your Honor, I think that there's reasons not to apply Vontes retroactively here. I think that there is some case-by-case determination that's required with regard to the substantive rights question.
Not Vontes retroactively.
Or yes.
The statutory amendment.
That's right, the
okay.
statutory amendment,
Yeah,
and continue to apply Vontes, at least for purposes of this case.
I'm sorry, I confused it by misstating my question. You are asking us to apply apply the statute retroactively. You are asking us to.
No,
Or you want to proceed under the Von Trest case.
yes, I think there's reasons to proceed under the three-factor test.
There's a reason, because you can win easier. Because if you take out that second factor, we have a Court of Appeals that said the first factor weighed in White's favor.
Yes.
And so if you take out the second factor, you're pretty much having to argue why the Court of Appeals was wrong, aren't you?
Well, I don't.
How can you win if we throw out the second factor?
I think that would be harmful to the state's case. I don't think it would necessarily be fatal.
And that gets to my question, which is Von Trest really a balancing test? I mean, was the Court of Appeals right to act as if it could determine which factors weigh in favor of which party and then balance them all against each other?
I think that was appropriate, Your Honor. I think that,
Why is that appropriate? That's not what Von Trest says.
Well, Von Trest sets out, three factors that can be considered. And I certainly think, I don't know that it necessarily is always going to be a, 1 versus 2 pure numerical circumstance.
There's nothing in that opinion, is there, that would indicate that courts are supposed to balance those factors against each other?
Well, I don't believe there's any language that talks about balancing, but I think that Von Trest does call on courts to consider those factors, and I think that in the process of considering those factors, in certain circumstances, balancing the factors may be what's appropriate, and I think that's what's appropriate here. Now, I will say that I don't know that, again, if it's applied retroactively, and I would say that probably the lion's share of the Court of Appeals decisions have applied it retroactively. The recent Dawson case, I think, offered maybe a secondary or alternate rubric for applying it retroactively. That's the State v. Dawson 116530 Court of Appeals case from last Friday. In addition to looking at substantive versus procedural, they took a look at, well, is this amendment just something that clarifies what we meant by the language we used at some point in the past? But even with that said, I think that substantive vested rights are important here, and I note that this is kind of a different case than, kind of some of what I think the imagined circumstances were when the legislature made that amendment. I think, just kind of looking at the testimony, the idea was that, we don't want there to be the second factor because we want to kind of close the doors on having to look at the merits of, petitioner's case if there's not actual innocence once we get past this 1 year period. And in this case, the state's argument is that, well, we should look at the merits, but we shouldn't look at them, they're not a favorable factor for Mr. White here. They're actually favorable to a finding that there is no manifest injustice and not extending the time limit because there's not really meritorious claims. And, I don't know that ultimately that distinction makes a difference. I found a case of this court some time ago, Jackson v. Americans Best Freight Systems. It's 238 Can 322, and it's a 1985 case, but it says that, when the court considers vested substantive rights and looking at retroactive application of procedural statutes, there's no distinctions between vested rights of action or vested rights of defense. And in particular, in that case, they looked at a vested right of defense that came from a statute of limitations running. So I think the fact that, the state is raising the second Von Trest factor as a vested right of defense shouldn't make a difference from if the defendant was raising it as a vested right of action as a reason to get in the door and file the case. And I think basically, that's concern of limiting some rights with regard to that are reasons that the Sherwood Court and the Noyce Court did not apply the amendments retroactively.
But let's look at prejudice to Mr. White beyond the statute of limitations, as allegedly contained in the letter that was supposedly sent, and the defendant says wasn't received. the defense counsel said that we're not going to file a petition for review unless you notify us. So not only did the statute of limitations on a post-conviction relief motion start to run, but also the time period on a petition for review to this court. And how can we say that we didn't have manifest injustice when he was denied those processes because he wasn't advised?
Well, I think that the manifest injustice determination, that's one of the things that I think should be taken into account. And I'll note that the state didn't cross appeal the Court of Appeals kind of determination that that first factor did run in Mr. White's favor. Now, that said, I think there are some reasons in looking at balancing, even if we're not talking about the second factor anymore, and I guess kind of for purposes of the state's argument on the strength of that, I'll just stand on the brief unless there's any specific questions.
Okay,
But-
now do you agree that the panel determined that the lower court's characterization of Mr. White's testimony about not receiving the notice as being self-serving was not a credibility determination against White?
Well, I would certainly agree that generally speaking, the Court of Appeals found that first factor, first consideration ran in his favor. I think that's one of the reasons for that.
And they found that it was defense counsel's obligation or duty to advise Mr. White, not his duty to act as co-counsel and monitor the litigation.
There's certainly
And-
some consideration towards that there.
You agree that's what they found?
Yes, that is what they found.
And my question is, what is defense counsel's obligation when you're going to advise a client that their appeal has been unsuccessful and that we are beginning some time clocks, one for a petition for review, another for a 1507? What is the obligation to assure that the client gets that notification?
I don't think that it would be unreasonable for defense counsel to follow up with that if they didn't receive a response to the initial question. That said, the Court of Appeals did recognize that even without that, there may be an outer limit where, the potential petitioner sitting on his hands and not finding out that information would be unreasonable.
And they've specifically found that outer limit was not present here.
No, but I think it is significant, that's a consideration. I also note that, the Court of Appeals indicated that factor ran in Mr. White's favor, but didn't necessarily indicate that that factor ran strongly in his favor. In fact, I think what they said is that he offers a fair, if not persuasive, reason for his failure to timely file. Now, on the other hand, if we look at the third factor, which in any case would still exist under the amendments to the 1507 statute, the Court of Appeals said a couple things about that I think were significant and I think were correct. First, they said that that's probably the most significant factor, that, truly what should kind of raise concerns of manifest injustice and fundamental fairness in the proceeding is if there's an innocent person or potentially innocent person who remains in custody. And then they said that this, most significant factor also weighed heavily in favor of the state in this case. And I think that it does. And I think that in any consideration, that should be something that this court looks at and any court looks at in determining manifest injustice, regardless of what the excuse is. And here, by my reading, Mr. White didn't make a claim that even approached innocence, certainly not a colorable claim of actual innocence, and certainly not a claim that would fit the statutory requirements in the new amendment.
Counsel, since we're on the statute, what in the statute gives any indication that even just the two reasons listed in the statute ought to be balanced against each other?
Well, I think that, if you look at the statute, there is an or between the two things that the court can look at. So I think, the court can make a determination as to which one of those, seems the most significant to apply in a particular case. And I think in doing that, there's some inherent balancing that's appropriate. And, again, I think in this case, these claims are so far and away from anything that would cause a reasonable juror to not have convicted White. I think that that would be the appropriate consideration or the overriding consideration in this case. And,
Counsel, I'm afraid I didn't understand your answer to that question. You started to answer, and I understood the part where you said the statute does use the word or, and then from there you lost me because it sounded like you were saying the judge can blend the two or consider both and then ultimately choose one.
well, I think the process is, somewhat of a balancing, but I don't know that I would say they would necessarily be blended. I think that it's more about finding which one of those would be most appropriate to the case, and then ultimately applying that factor as the overriding factor.
All right, thank you.
Thank you. And if there are no other questions, I'll just ask this court to affirm the ruling of the District Court and Court of Appeals that there was not manifest injustice in denying this claim as untimely.
Any more questions? Thank you, counsel.
Thank you.
Counsel, I need to check with the clerk. My notes don't show that you reserved any rebuttal time.
You're right, I did not. I apologize, Your Honor.
No problem. We thank both counsel for your arguments this morning. Court will take this matter under advisement.